Namaskar, bonjour, and good morning. I am very pleased to be invited to give this speech and share my thoughts on the Constitution Day of India, today, the 26th of November 2020. I would like to share my thoughts in this unique environment that we as lawyers are not particularly used to, not having an audience, not having to share the thoughts and being contradicted by our adversary lawyers and so on and so forth. However, I will try to do my best to share the thoughts with you, as I think it is essential today that we, the people, are the most important facets of our constitutions. And that is how we have selected this subject, we the people and our constitution, obviously India and France as it is in 2020. I would briefly read the preamble of the Indian Constitution, which says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens," and then it goes on to the rest of the Constitution. Effectively, there is no doubt that the constitutions are more relevant today than ever before, whether it is Hungary, in Turkey, USA, France, Thailand, and of course in India. We always refer, the leaders always refer to the respective constitutions, and yet we see there is crisis, so to say, and so on and so forth. However, it is my view that the fact that we begin the Constitution with "we the people give unto ourselves" is the real feature of a constitution and the most important facet, which we will see between India and France, both sharing the same aspects of a democracy, which is solidly enshrined in the people as well as in their constitutions. I would like to give a short background to the history of the Constitution, how they took place, how it began. Thereafter, I would pick up a few of the essential features of the Constitution, starting with the Constitution of India and comparing it with the corresponding facets in the French Constitution, and thereafter draw some attention to the important conclusions that I would like to draw and share with you. I would like to begin with the history of the Indian Constitution. It is almost 100 years now that the first Government of India Act 1858 was promulgated, which is the precursors to the Constitution, and very shortly it will be 100 years that the Constitution has its origins in the Government of India Act and as it is today. So the first act was 1858, which was thereafter 1919, and then 1935, and then finally the Constitution in 1950. I would like to draw attention to the fact that we in India are an Anglo-Saxon common law system as compared to the civil law system which exists in France. However, it is my view, and I believe, that when the British introduced the statutes and codes in order to govern the territory, a diverse country like India, we, although a common law country and Anglo-Saxon, we should not have written laws to a large extent, but in India we did have this introduction of administrative codes, the civil procedure code, the criminal procedure code, the penal code, and so on and so forth. This is, I believe, a similarity with the French system, which is essentially and substantially written laws, and therefore we have something in common with them. Of course, there are always some funny stories about how do we govern a country which speaks so many languages as in India, and different people speaking hundreds of thousands of dialects, whereas in France you have 135 types of cheese, as Charles de Gaulle said. How do you govern a country like that? Maybe these are also the peculiarities of the two systems of India as well as France. Now, going back to the nitty-gritty of the situation, the Indian Constitution has 395 articles, which are divided into the fundamental rights, which are articles 12 to 35. Then you have directive principles, and then there are the schedules. Now, these are basically the facts which are written into the Constitution, we the people giving ourselves the right to be governed by a certain set of principles. The same thing is also seen in the Constitution of France, which was relatively recent in the sense that the current one is 1958, has only 88 articles, but it has its origins in the 1789 Declaration of Rights of Man and an earlier constitution which was in 48. The Indian Constitution, by comparison, has undergone 104 amendments, the last one being 25th of January 2020, which was dealing with the rights of uh, giving reservations to certain uh, elected nominees from the scheduled castes and scheduled tribes uh, to the different legislatures in India, including in the parliament. However, that apart, we would now like to say that in the French Constitution we have not seen any amendment so far that is of any consequence at all. But uh, there is some aspect of the French Constitution which has a slight difference in terms of the essential features. One of the essential features of all constitutions is that there has to be a rule of law and it effectively guarantees freedoms. Now, that is seen effectively in the French Constitution, which makes it a solid democracy. The same is the situation where in India. The French Constitution is also secular in nature, where the religion is kept separate from the state, which is the same in India. And there is the question of separation of powers, which is also there, but there is some difference. The whole idea of my sharing these thoughts and drawing attention to these important aspects is what are these essential features which are different and yet both are supposed to be vibrant democracies with these differences. The other factor, the three essential features which I feel is democracy, guaranteeing freedoms, separation of powers, the power of judicial review. These, in my view, are the three essential features which we need to understand as they exist. To draw a comparison with the Ayurvedic system of medicine as it exists in India, we have the three elements which have to be maintained in a particular balance, which is the Vata, Pitta, and Kapha. Now, in order to have a perfect health, and we must have these three essential elements in balance. In the event there is an imbalance, we suffer poor health. Now, the separation of powers under the Constitution is something like the Vata, Pitta, and Kapha, which has to be maintained in a balance, which is the executive, the legislature, and the judiciary. These three elements, which are the three powers, which any constitution seeks to separate and maintain a balance and a cross-check, I feel that we can draw an analogy about the health of a nation by maintaining these elements in power, in that are the powers, and to maintain a good health of the nation as compared to as we would like to have a good health ourselves. We the people eventually also need to be healthy to see a healthy nation. In France, under the constitution, the separation of powers is almost similar, except that the French judiciary is not really a power center or a power as it is understood in India. The main difference is that there is no judicial review power that is there with the French under the French constitution. A very limited judicial review was given under the 1958 constitution, where a cour constitutionnelle was introduced, which can set aside certain provisions of a law that has been passed by a parliament, uh, which they may pass the whole law, but it may be subject to certain established limits which can be examined by the cour constitutionnelle. This is the only power that exists and hardly been used in France. This was a small break in tradition under the French constitution because President Charles de Gaulle wanted to focus, as it is the case sometimes, the power to be focused into himself so that there should not be any dilution of power from the president. Now, that apart, one of the strongest pillars of our constitution in India is the power of judicial review by the court. The highest judiciary has held extraordinary power and it has been interventionist, recognizing social welfare rights, passing wide-ranging interim orders that assess the work of the executive ministries at regular intervals, and even striking down certain constitutional amendments. Now, this power is extraordinary, which distinguishes the Indian constitution and the founders of our nation and the constitution uh, gave it in their wisdom this power to the courts. This has been exercised and in order to show how it has evolved and what is the current status of it, I would like to address you and share my thoughts on a interesting evolution that has taken place since the 50s till today, which is called or referred to as the basic structure cases of the Constitution of India and its evolution. What is this basic structure? Is there a basic structure? Is it possible to amend the Constitution? To what extent can it be amended? So on and so forth is the main issue which the power to validate or invalidate any amendment is given to the Supreme Court finally to judge the position. Since the 50s, in the 50s, 51 to be precise, the question of right to amend the Constitution, the power to amend the Constitution was decided finally by the Supreme Court, which gave the full freedom to amend the Constitution as the Parliament wished. In other words, they had full power to amend the Constitution, including the fundamental rights itself. Thereafter, it changed where there were some fundamental rights could not be changed, was decided in 1967. Thereafter, we went on to 1973 and 1975, wherein 71, 73 and 75, where finally in 75, during the emergency days, the Supreme Court held that the fundamental rights itself could be abrogated, including the right to habeas corpus. But in its own wisdom, which is the most impressive part of the judicial function, or the vata, pitta, and kapha functions, which I say, is that it balanced the imbalance that may have been created. That is when they introduced the concept of basic structure. What it said was even the rights, fundamental rights, etc., could be abrogated, except unless the basic structure without touching the basic structure. That is to say that the basic structure of the Constitution should not be changed. What is the basic structure is not defined even today. We don't know what is the basic structure. I have my own views about the basic structure. I believe there is no such thing as a basic structure. The Parliament has full power to amend, to change, to decide what is in the interests of the country. However, in its wisdom, the Supreme Court introduced the concept of basic structure. Whether it is right or wrong is, of course, to be judged on a later date, whenever it comes up. It has hardly been used in the recent times because the Supreme Court itself and the judiciary itself has come under heavy criticism lately for virtually not taking any decisions, allowing delays to take place. Important matters were not decided. It allowed the state to take its own time, and interventions by the court and judiciary was not at all done, whereas it intervened in a more forceful manner earlier on. The press has been critical in India about the Supreme Court, about the actions in the Jammu and Kashmir issues, the conduct of elections in Maharashtra, and so on. However, there is a system that has to address the faults as they arise, which happen to be the Supreme Court and the judiciary. Whereas if they don't exercise that power or delay that power, there will be, as I said, an imbalance. Of course, we cannot criticize or blame the government, the legislature, or the executive for an inaction by one of the wings of the government. So therefore, we have to bear this aspect in mind because these are the conclusions which I draw uh, from the current situation in India. Unlike in France, the judiciary in India has considerable powers of its own in the sense that it cannot be overridden easily due to the power of judicial review. Now, this power doesn't exist in France, yet it is a functional democracy, and we are seeing a lot of debates going on and new laws being passed in France to deal with issues that are cropping up from day to day. Now, this aspect which I would like to share and point out once again is something which is another essential feature which we talked about earlier was the secular nature of our constitutional systems. It is enshrined in both the constitution. Can the state get involved with religion in one form or the other? This is an issue that has often been cropping up in debates and discussions both in India and in France. Now, this is an aspect which can be finally decided if it has become an issue by the judiciary in India. Whether it has done so or not, is not for me to sit in judgment about over it. However, this is a factor which is been a bit puzzling, because as a lawyer I find that sometimes the judiciary, highest judiciary, is either absent or is silent. Now I'm sure the time will come very soon when they will exercise their right, and the people, we the people, will not sit quietly without exercising our right to speak, our right to share our thoughts and express our views. After all, as we see, we have to remember that and not to forget that the Constitution is, after all, it's the we the people who have given it unto ourselves, and it is for we the people who should intervene and speak if we are to have a healthy nation and a healthy democracy. I think I have perhaps exceeded the time that I should have, but I will be very happy to address any questions, and please contact me at my email or via the Indian Embassy. You may reach me at Phadke vmp@phadkelaw.com. Thank you very much for your attention, and I wish you a very happy Constitution Day. Thank you.